My lord, item number 8. Mr. Taraknath Haldar is appearing for the respondent, my lord. He has not come today, my lord. I am praying for a day's accommodation today, my lord. Only accommodation for today.
When the matter is called up,
My lord.
I seek my lord's kind leave to meet.
inclusion.
Item number 30.
Mr. Taraknath Haldar is appearing for the respondent, my lord. He has not come today, my lord. I am praying for a day's accommodation today, my lord. Only accommodation for today.
When the matter is called up,
My lord.
I seek my lord's kind leave to meet.
inclusion.
Item number 30.
Mr. Taraknath Haldar is appearing for the respondent, my lord. He has not come today, my lord. I am praying for a day's accommodation today, my lord. Only accommodation for today.
When the matter is called up,
My lord.
I seek my lord's kind leave to meet.
inclusion.
Item number 30.
देखें just
You don't write.
My lord, very much. I seek my lord's kind leave to mention item number 36 of my lord's today's cost list, my lord. My lord, kindly do not take me amiss, my lord. This matter is pending for quite some time. We are the degree, my lord. We are the degree holder. My lord, we are the degree holder. I have a ground for reasonable requirement. It's a property, 2,000 square feet property in Kamak Street, my lord. My lord, I have some urgency in this matter, my lord. The only problem, my lord, I am humbly praying for.
This rent used to sit regularly. At that time,
correct.
nobody took the initiative.
My lord, kindly, I am praying for release of this matter so that we can move it before.
Well, I am not
Okay.
asking for release. I am asking for lordship before lordship subject to kind sanction.
My lord, in this matter, my lord, I am for the appellant. That could be responded, my lord.
You are for the
My
respondent.
lord, I am for the respondent. I am the degree holder.
You are seeking release of the matter.
My lord, I am the degree holder. My lord, they are enjoying the property. They are not in hurry.
My lord, they are enjoying the property. Not only that, my lord, for the last.
How many will speak?
My lord,
My lord, I'm being late.
You are for it?
No.
my lord, I am also for the respondent. My lord, he's my Lari junior. My lord, the only thing is, my lord, for the last 3 months, they've stopped paying the rent also. My lord, they are enjoying, my lord, they're enjoying a property of 2,000 square feet for more than 15 years now, my lord. We've just got rent for about 1.5 years. That is it, my lord. This, my lord, pursuant to your lordship's order, my lord, several directions were passed. Paper book is also ready, my lord. Everything is ready. But since your lordship is sitting in the division bench, my lord, your lordship is not being able to pick up the matter, not sitting singly. That's the only reason. Otherwise, we do not have any difficulty, my lord. In fact, we had mentioned the matter before, in courtroom number 4 also, my lord. Your lordship was pleased to direct us to mention it when your lordship sits singly.
Yes.
That is the reason, my lord, we are mentioning. We are only beseeching your lordship, my lord.
What do you intend now?
We are only praying with it. Though they are appeal, my lord, but we are suffering, my lord.
What do you intend
If
now?
your lordship, my lord, kindly releases the matter, my lord, then we shall try our luck before another division.
Releasing the matter, my lord, I am. And
They have every reason to do that, my lord.
and the other submissions made by management, that is not correct. My lord, I can give your lordship a brief fact of the matter, my lord. It is not true that since last 3 months we are not paying rent. Well, initially the order was, the conditional stay was granted. The order was first to deposit ₹10 lakhs to the register High Court.
No.
We have deposited. We have done it. Number one. Number two is the rent was, occupation charge was fixed as ₹25,000. We were paying that. All right. Here my learned friend is. You were paying. I was continuously paying. Now, presently? Till October 24, we sent a check that has been encashed by them. Then my next thereafter, then my next check I sent to them. They returned it to us, saying the name of the respondent is a private limited company. The name of the company has been changed, so you give me in new name. Well, the order was to give in the name of the respondent in the amendment has been sought for. that application is pending, my lord, before your lordship, as item number 36. My lord, I am sick.
I shall,
From- And even thereafter, my lord, I sent check, they returned it. Till October
Okay, item number?
36.
my lord, the statements my lord made, my lord, September,
We're not going into the statements now.
my lord, what they are saying, my lord, for the last 3 months, we have not received any rate, my lord.
On the next day, when this bench sits singly, this bench will be available. I'll take up the matter
Yes, my lord.
for
Kindly.
hearing.
It will be your lordship's pleasure, my lord, to take it up
Hearing of
sometime today, my lord, at least. My lord, and the application that has been filed before your lordship, my lord, is
If it
for
reaches 36, then
recording the death of the my lord appellant, not because
if
changing the name of the respondent. My lord.
if it reaches to item number 36, then it can be taken up. Otherwise, how can
We shall be here, my lord. We shall be here. My lord. It's
Okay.
been-
there won't be any adjournment, Learned
I'm not
Counsel.
afraid yet.
I will show from your lordship, Lord, I mean, all
I have
in all
continued-
last all occasions they have prayed for adjournment.
Next,
Regard to the item number 26, 27, and 28, I have mentioned before Lordship when you're sitting Lordship division bench or your Lordship. Kindly take up this matter. We are suffering because we are the judgment degree holder. My lord, we are
let the
suffering.
matters
I know,
be
my lord.
taken
I got your
seriously.
Lordship point. So far, my lord, the communication.
Let the matters be taken up serially, well,
Kindly
because
take note of this point. My
part-heard
lord, we are
matters have
suffering.
been given
I can-
preference.
Lordship.
Any other mentioning?
Grateful.
Dr.
Item 1. Item 2.
No matter what the- চলে যাচ্ছে।
You are seeking to be added.
Yes.
So, where's the appellant?
Appellant may not object to my application. That is the respondent.
The respondent is opposing to you. But in the absence of the appellant, it is passed over. Next,
Item 3.
Fine for the applicant. Mr. Gopal portion is appearing for the respondent. Seems he's not there. And
passed over. Next,
Item 4.
Oh, my lord, I'm for the respondent. Duly briefed in this matter. Unfortunately, we are facing certain difficulty, my lord. Certain documents are not available with us, such as the plaint in the instant matter. Some plaints, some written statements, they are not
what to be
available
done
to
from
us.
this end? What to be done from this end?
My lord, if your lordship allows, we can obtain the copies because LCR is lying with your lordship, my lord. Then if we can be
it is
given leave to
available with
apply
your
for the
It
copy,
is available with your client.
my lord, it's not available. That is
How can it be?
unfortunately why.
How can it be? It is partly heard.
My lord, otherwise we are ready to proceed, but without these plaint and other documents, it will be difficult for us to place our case.
It
My
is
lord,
with your client. It had been taken up. It is partly heard.
My lord, we are newly
cannot be
briefed in
taken
the
up now.
matter. My lord, that is the problem.
Then you will have to face consequence.
My lord, we are otherwise ready to hear
If it
further.
hadn't been partly heard, then your issue could have been resolved.
My lord, I'm otherwise ready with the matter, my lord. Although it's slightly complicated, my lord, we are prepared with our arguments, my lord. It's just that to satisfy your lordship only, we would prefer if we could show from the plaint and the other documents where the case lay, my lord. My lord, because otherwise, my lord, kindly see.
In a second appeal, which two have been partly heard, you are now raising that you are not having the copy of the plaint. This cannot be entertained at all.
My lord, this is what I've been
Between you and your client.
what I've been saddled with, my lord.
Take the help of your adversary.
My lord, I can proceed with the matter right now. I'm ready. Otherwise,
In the absence of the appellant, it cannot be proceeded. Take the help of your adversary and obtain the necessary documents or the papers which you require.
very well, my lord.
Next,
Item 5.
So, my lord, in this matter, I appear for the respondent 1 and 4, my lord. My lord has been
Let us
pleased
start.
enough. My lord has been pleased enough to grant me time
Let us start. Let us
in this
start.
matter. But the only thing is that,
Nothing to be
sir,
heard
only,
except hearing.
my lord, only one thing, my lord. Only one thing. I was not in Calcutta. Just today morning, I have returned.
You start.
Only
You
1
start.
day
No,
accommodation.
start.
Only 1 day accommodation.
No. No
But
accommodation.
their
No
accommodation is
accommodation.
complete.
You have got accommodation from the month of November. You have obtained.
But only one
December,
thing.
December, January passed by. You
But
start.
kindly pass it over for a moment, for some time. Kindly pass it over. I will start at 3.
2:30.
Respondent.
At 2:30.
The minor is not kind to grant adjournment. ঠিক আছে ঠিক আছে আমি বললাম মাইনর কাইন্ডনেস দেখাচ্ছেন adjournment হবে না পরের দিন হবে
Item 6.
This one I am appearing for the respondent. If your lordship may kindly consider the last order passed by your lordship.
Item number কত?
6 and 7 হবে? 6 তো
6 and 7.
Last year, complete. Yes, and 5.
First thing.
না
Oh, page.
So,
Oh, it's
within time. বলেছেন আগের দিন my lord was pleased to ask me to produce the death certificate of the disease because it was hard and only for finding out it is argument by learned friends already been filed and my it is notes of argument you can be filed. In the meantime,
Filing the written notes of argument.
yes, they have already
It has
filed.
been filed.
Yes, and for me it was pending. Today,
Yes. On behalf of the appellant,
It was
written notes of argument has been filed.
yes, and it was fixed for filing a written argument so far the respondent is concerned. In the meantime, died my lord, accordingly filed an application for substitution.
Who has expired? Who has
The
expired?
respondent
Respondent.
within
Sole-
time.
Sole respondent.
Sole respondent died. You file an application for substitution within the period. The last action, my lord, is of the opinion unless until you produce the death certificate. It is
Yes.
this is a copy of the
Can
5, my lord. My lord is of the opinion unless until you produce the death certificate. It is
yes.
this is a copy of the.
ঠিক করে করুন ঠিক করে করুন ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে ঠিক করে করুন Paragraph number 2.
Yes, my lord.
Shikha Rai Chaudhary, wife. Sushmita Rai Chaudhary, daughter.
Anita and Shomita. Smita.
Anita Chatterjee, daughter. And Smita Banerjee, daughter.
Daughter.
Vishwanath Rai Chaudhary expired on 15/7/2024.
Yes, my lord. These are this. And it was filed, my lord, on 27/9/2024. Within the period of petition.
Correct, counsel?
Because my lord is of the view that something should be on record to show that.
Yes. Why two?
Oh, true. It's the same copy, my lord, probably, my lord. Just hand it over to your lord. For giving more protection.
In-
are already
in-
protected.
in-
From pillar L to double L in pillar 2. And this is our did not solve. It's not the respondent.
Note about it.
আমি এখন ফিল্ড
Can 5 of 2024. The learned counsel is presenting the sole respondent, namely Vishwanath Rai Chaudhary, admits that said Vishwanath Rai Chaudhary has expired on 15/7/2024 and he seeks substitution of the said sole respondent by substituting his legal heirs whose names are mentioned in paragraph 2 of the said petition, namely Shikha Rai Chaudhary, wife, Sushmita Rai Chaudhary, daughter, Monita Chatterjee, daughter, and Smita Banerjee, daughter. He further submits that the said application seeking substitution has been filed within time, that is on 26/9/2024, 26/9/2024. That is within the period of limitation. The learned counsel is presenting the appellant
appellant.
Does not raise any objection. As such, let the name of the deceased respondent, namely Vishwanath Rai Chaudhary, be substituted by his legal heirs, that is, wife and three daughters. First of can 5 is disposed of. Raised to do the needful.
And there is another can because 2 appeals are there.
Oh, there is another one.
This is can 1 of 2024.
Can 5 of 24 is in respect of essay 33.
Yes, my lord.
The 33 item number 6.
Yes. Subject to question, my lord.
Yes, 33 item number 6. In respect of item number 7, 34.
Yes, my lord, can 1. Same, my lord. Same.
There is another one can reflecting in the process.
That is in respect of item number 6 probably.
It has been mentioned twice.
Same order, my lord. This is a copy of the dissertate for.
7 এর জন্য।
The 7.
7. Item number 7. It has been mentioned in the paragraph 2 of the same
Same.
application.
Nothing.
Same order of 7. The learned counsel representing the respondent files written notes of argument. Let the written notes of argument be kept to the record. Stop. Reserved for judgment.
Yes, fine.
Citation authorities will complete হয়ে গেল 6 can 5 আর 7 হচ্ছে can 1.
Eight.
My lord,
But,
item 8.
I put the appellant below. I have done my submission. I have given my submission. Now it's
Completed.
now it's started to
Completed.
my submission is complete.
My lord, Taroknath Haldar will respond. He's appearing for the respondent. I am praying for a day's accommodation
Are
today.
you the advocate on record?
No, my lord. He instructed me over telephone. I have come and submitting before your lordship. My lord.
When I am out of possession of the property since long.
Only this.
I am the
accommodation, my
landlord, owner, living in rented premises. Can you let me, if you so permit, I can serve a peremptory notice for the next date.
She has.
Today only.
Learned counsel.
My lord. Only a day's accommodation is on.
Inform the learned advocate on record that the matter will be taken up on the next day positively.
My lord.
Lordship.
In after 11. Learned advocate representing the
Respondents, man.
respondents. Learned advocate representing the respondents seeks an accommodation on the ground of the learned advocate on record.
Oh, yes, Mr. Taroknath Haldar.
These are good.
For the respondent, Taroknath Haldar.
Respondent. Third considered. Stop. Let the matter. The matter is adjourned. The learned counsel representing the respondent is directed to come prepared on the next date positively for hearing.
Lordship, I'm the appellant, I'm for the appellant. Lordship, I'm paying for not to actually. Landed advocate, I'm appearing for landed advocate. University is appearing in this matter in within code number 236, Lordship. And several matter of fees today. And this
We kept with the record, Lordship, the appeal is pending before the Municipal Building Tribunal under section 401, subsection 3. Lordship, let it be kept with the record. Lordship, after completion of tribunal order, there is a separate cause of action. Let the writ application be
What is
disposed.
the issue? What is the issue? Item number
9.
Item number 9, essay 171 of 2009. 2019.
13757.
Where from? Where from you're getting that?
13757.
Where from you're getting that?
171.
Second appeal.
Item 9. Sorry.
Court heard matters have been kept first. Yes, you are representing the appellant.
Lordship,
What
and
is the
led
prayer?
by Mr. Onimus.
What is the prayer?
Lordship, I'm paying for only not today, Lordship, in this matter. Kindly make it not today or fix a date.
The order will be passed after second call.
Lordship, there are in the courtroom number 236, there is a
Order
several
will be
matter.
passed after second call.
Oh, Lordship.
Learned counsel is present in the court. He is
Lordship,
present in the court.
is in 236 and several matter was there, Lordship. And the only Friday the court sits the then second half. There are several matters, Lordship. Item number 1 to relating on another matter. Kindly make it not today,
After
Lordship.
second call, the order will be passed.
Lordship, please.
Next.
Item 10.
Item 10, I am for the appellant led by Mr. Rohan Banerjee, Lordship. The advocate on record has, due to his personal difficulty, he has to leave the court today. I am praying for only not today in this matter. This is a part-heard appeal. Mr. Banerjee has completed his argument. The argument for
What
the
today means adjourn for sine die.
Lordship, kindly make it not today, Lordship. It's the respondents. They have started their argument. Mr. Banerjee has completed his arguments for the appellant. The respondents have commenced their arguments and they are continuing with their arguments. They are not.
Next.
Lordship, item number 11, Mr. Court,
My lord,
Mr.
এই শুনতে পাচ্ছি ও না তো তাকে বলছো না No, my lord, I wanted to be a hero. I wanted to no
That is not the case. Something has
মাঝখান
operated.
মাঝখান করি আর বিপদে বলে আমার এখনো বিয়ে হয়নি তার
Unable to
ইয়াং
hear.
মেয়েরা বলবে বলে বাবা
Unable
এবার
to hear.
জোরে ক্যাটারার উপায় নেই
Lordship, Mr. Kolal Basu is honorable the appellant, Lordship. Lordship, I am praying for only adjournment, Lordship. He has left the court, Lordship, due to his illness, Lordship. Today only for
Basu has left the court.
left the court, Lordship, due to his illness, Lordship, because today his argument, Lordship, for analyze the judgment, Lordship.
But one thing is
Already
very-
the facts,
no, no,
which he has
actually,
concluded.
It was heard.
It was
Mr.
heard.
Basu has stated that
he will hand over some judgment
Only some judgment, only
along with that written
written notes.
to us also. So that we
Kindly,
can,
I am praying for only one
No, no,
day
nothing else.
adjournment, Lordship. Next.
nothing has been done.
means adjournment sine die.
Uh,
That's the problem.
But today, the court, Lordship.
Learned
for it.
counsel-
they ought to have supplied this, comply the court's order. It's very unfortunate.
Learned counsel on the next day positively when this bench
Definitely.
takes England.
Then whatever this judgment and note, that should be well within time they should have.
Has to be furnished.
Okay, can you fix the date, my lord? Otherwise they will do that. By Thursday. By Thursday they will supply.
But Thursday,
আরে তুমি জানো না যে জাজমেন্ট
written notes, judgment দেখাবে তো। তারপরে তো written-
দাঁড়া দাঁড়া তুমি কি আর্গুমেন্ট করবে না
next date এর আমরা দিই তো, বলবে তো।
তাই তো আন্ডারস্ট্যান্ড ওয়ান মিনিট তুমি কি আর্গুমেন্ট ফার্দার করবে না জাজমেন্ট সাইড করে
Argument
আমাদের
further করবে তো। এটা বলা সেটা তো জাজমেন্টের
As far as I can recollect, it has been heard at length.
রাইট
Only citations are to be
only
provided.
citation is concerned.
so they are concerned then I'll distinguish
Let the citations be provided
By next week,
by next week.
by next week,
so that I
So
actually
that when this bench sits once again,
as well as
yes, Lord.
next day I'll
Take
finish
up the matter.
if they finish I'll finish no problem.
Mr. Banerjee, you have finished.
No reply reply I'll have to give
Reply.
that I'll give
That will be for a short span.
of course my lord why should I waste your loss of valuable time প্রবলেম হচ্ছে আপনাকে তো পাচ্ছিই না তাহলে তো কোনো সমস্যাই হতো না আপনি কত আগে ডিসপোজ অফ করে দিতে পারতেন
ওনার নামটা নিয়ে নেবেন। Mr. Ram.
জাজ
Seeks an accommodation. Seeks an accommodation.
অভিযোগই পাচ্ছেন না জাজ সাহেব
The senior. He further submits that the citations which are to be provided. You can refer now. We have
No, Lord.
the citations which are to be provided will be provided to the adversary by the next week.
as well as
The
by 5th
By 2000.
by 7th, by 7th, by 7th.
তাই কর
That is sufficient time, sufficient time.
yes sufficient
4 days minus 1 day, 3 days.
yes আরে প্রিএমটালি সেদিন বাচ্চা যদি না বসেন I cannot detail that very well, but they must have the copy that is preempted.
So the copy of
The judgment,
yes, they will provide by 7th, by 7th, by 7th.
For as my lord, again he'll come with his sweet innocuous face, my lord, and we will be compelled to allow him.
মহিলারা তো ভালো বলছে
জানি না স্যার
আমাকে কেউ বলে না জানিস ওই সেদিনটা থাকার চেষ্টা করি নো মাই লর্ড ইজ নট ফাইন আরে সুপ্রিম কোর্টে হিন্দি চলে আর এখানে কি হ্যাঁ
The learned counsel representing you are for the appellant, no?
Appellant representation.
Appellant is directed to be ready for hearing for further submission on this issue on the next date positively.
as of suited. Now may I leave my lord?
It will be the court's pleasure if you be seated here.
No, my lord, as a Friday. As a Friday, take to let me enjoy in my own way. Friday is a different date.
May it please your lordship. Lord, I appear on behalf of the appellants in this matter.
How many applications are pending?
Yes, your lordship, there are 4 applications pending.
Can one
Can one-
2019
Can
relates
one,
to
that is my lord,
the respondent?
even on the last occasion, lordship, they didn't appear. I may indicate, your lordship, there are 4 can applications, your lordship.
Yes.
Can 1 application is my lord for section 5 application for this for admitting the appeal. Condonation of delay for 42 days.
42 days.
Yes. Can 2 is your lordship the application for stay of the impugn order. Can 3 your lordship is the substitution application. Can 4 application it was withdrawn. Your lordship kindly recalls it was withdrawn because both the prayers were clubbed together in the single application for setting aside of abatement and for my lord condemnation.
Let it be admitted first.
Yes. Can
Thereafter-
5 can 5
Thereafter, all the applications will be taken up.
yes, sir.
After
Now, my lord-
after disposal of section
Can-
5, after disposal of section 5, let the matter be admitted. Thereafter, the other applications will be dealt with.
But my lord will hear first can 1 application.
That is the section 5 application.
Section 5
Barring that, no other applications will be taken up.
my lord.
Only section 5 application will be taken up.
Very well, my lord. If my lord kindly allows us to make a notice to the respondents, thereafter, my lord, it can be heard, your lordship, because even today they are not appearing.
They have not entered appearance.
They have entered appearance, but they are not appearing, my lord. Even on the last occasion, they didn't appear. So this is the
But, sir,
difficulty, my lord, we are facing.
You can serve notice. Nil. Nil. File the if the appellant is being represented while none is representing the respondent. Full stop. As such, it is adjourned. Let the matter appear on the next date. Next.
My lord, if I may humbly indicate, my lord, this is the sole appellant. Sole appellant was there. Thereafter, we have taken out application for substitution and my lord, then condonation of delay and the abatement. That is what I am humbly indicating.
So the substitution first.
Yes. Can 3 is my substitution application. Can 6 is my condonation of delay for preferring substitution application. Very well, in the meantime,
Those two will be taken up only.
Fine.
Apart from those two, no other applications will be taken up.
Otherwise, we were ready, my lord, with the judgments and everything.
You serve notice upon the other side.
Deeply opposed.
Item 30.
Next.
Item 13.
I am for the petitioner, my lord. But in fact, my lord, last occasion, my lord, I paid for my lord
for filing, my lord, affidavit in my lord, exception, my lord, to the report filed by the state, my lord. But it has already been prepared, my lord, but it has not been, my lord, affirmed, my lord. So, my lord,
Not affirmed.
not affirmed. Only give 1 day time, my lord, so that not today, my lord, next occasion, my lord, I shall file, affirm and file it, my lord. Not today. Grateful. You are the petitioner. I am the petitioner.
Item 15.
I apply for the Panchayat.
My lord, I am for the petitioner.
But kindly have a look at your lordship's last order. Your lordship wanted them to produce, the sanction plan.
The very outset, I want to submit. But today I did not bring the brief.
It was not mentioned in the cause. It has suddenly come up in supplementary to supplement.
My misconduct, my lord.
Lordship, kindly take a look at your lordship's last order.
I'm just praying for a 1 day accommodation, my lord.
Petitioner or the respondent number 3. You are for the petitioner.
Yes, madam.
You are representing
Private respondent.
respondent number
7.
7. And you are
For the
representing
Pradhan. Respondent number 4. Pradhan Panchayat. 3 and 4. Respondent number 3 and 4.
3 and 4. And you are?
I am his assistant.
You are representing Ram Gopal Agarwal.
Probably on last occasion, you are
For the state. Miss A. Das Field was representing for the state. She was representing the state. Yes, it is.
Lordship was pleased to give a last opportunity the private respondent to apprise this court about the
Status
construction.
and position.
Lordship also wanted to see the site plan, the sanction plan, if they at all have any, for raising the construction. Because the Panchayat did not give any permission.
Yes, Senate Council.
My lord, kindly take action, my lord. My lord, on the last occasion, my lord, the Panchayat authority filed a report to your lordships, thereby disclosing the factum that the building which has been raised by the private respondent is unauthorizedly and without obtaining permission, my lord. My lord, the report has been placed before your lordships, and my lord, the allegations of the petitioner is also the same, that the building has been raised without obtaining permissions and violating the rules.
You had filed a report.
I filed it.
Inspection report.
Yes. It's 26 July 24.
2020.
26 July 24.
It was concluded that the private respondent.
Yes, the respondent number 7. It should have been respondent number 7, or he should have been mentioned by name, but the private respondent in this petition.
Did not have any sanction plan for constructing the unauthorized building in dispute, and such unauthorized construction has a space of around 11 inch on the western side, not even 1 feet.
That is their
And
allegation.
3 feet
That is why they
space
come up.
on the eastern side, they have left
3 feet
3
space.
feet space. The eastern side from the petitioner's building.
Correct?
Yes, Senate Council.
this 1 day accommodation, because I have never sought for any accommodation in their matter.
You have not represented on the last occasion. How could you have sought for accommodation on 12/12? None is representing either the petitioner or the respondents number 3, 4, and the respondent number 7. On that date,
Last occasion, he was represented.
No.
My lord, 11 December.
11 December. 12 December.
11 December, my lord, this order was passed, my lord. And 12 December, due to some reasons or others, this matter was appeared in your lordship's case, my lord. But on, my lord, kindly see, my lord, the order dated 11/12/2024, my lord.
One day prior to that.
Direction is of 11th of December. And my lord, kindly see, my lord, the 11th, the order dated 11/12/2024, my lord, there is lordships was pleased to give directions to the respondent of 7 to file exceptions, and last opportunity was given there, my lord.
Last opportunity.
Yes, my lord. My lord, kindly see, my lord, the last line, my lord, of that order.
No further opportunity will be granted after the Christmas vacation.
No further opportunity will be granted after the Christmas. Correct, counsel.
Just saying before your lordship, one day accommodation matter. Now it's up to your lordship.
Item 11. The learned advocate representing the private respondent, namely Ram Gopal Agarwala, seeks an extension of time.
One day accommodation.
What do you want? Do you intend to file an exception, or do you intend to obtain an adjournment? Do you intend to file an exception or not?
Just paying for adjournment, simple adjournment.
Let them produce a sanction plan.
My
Everything
lord,
will be
my lord,
clear.
the report has been
Let him
submitted.
produce a sanction plan.
Hey, my lord, kindly extend the time. Kindly extend that.
You don't even have the brief with you, and you have dared to.
But only today, my lord, madam, just I'm tendering my unconditional apology, my lord. Right.
Extension of time to file exception to the inspection report dated 26/7/2024, filed by the Pradhan Korimpur 1, Roman 1, Gram Panchayat. Full stop. Consider the submission. The extension sought for is granted as last opportunity. Full stop. The learned counsel, the learned advocate representing the private respondent is directed to file the exception by 10th of February 2025. Full stop. And no further adjournment will be granted.
One thing, your lordship, on the last occasion directed them, although it is not reflected in the order, to produce the sanction plan and any permission, if any, from the.
So the exception, whatever they will
Your
find.
lordship kindly directs them to file the sanction plan.
Sanction
Everything will be clear whether they are sanctioned or not. Let them produce the sanction plan, because we have not given them any sanction.
Only weapon which he possesses, that is the sanction plan. Yes. Apart from that, there won't be anything. If it doesn't
produce the sanction plan,
if he intends to evade from that, it will be presumed.
lordship.
It was fixed at 2:30.
The trial court, the suit filed by the plaintiff
was dismissed on contest. Challenging that order, the appellant plaintiff filed a appeal before the appellate court. The appellate court admitted the claim of the plaintiff in part. But I'm straightway coming to page 33 of the paper book. That is page 12 of the judgment which is imputed in this appeal. Or the second last paragraph. Under the given circumstance.
Your Counsel, can you recapitulate the moot point?
The moot point is that the appellant in this court has encroached upon a land which is a common land.
Belonging to both of you.
Both the parties.
You are
But the
adjoining
title,
landowners. Both of you are
yes,
adjoining
Malat,
landowners.
this is the A schedule property which belong to me. This is the B schedule property. The ownership belongs to me, but that can be used by all the persons residing in the locality, because that is the only passage for ingress and egress of both myself as well as the appellant.
Through any agreement or any deed,
There is a deed. There is a deed.
has that been exhibited?
Yes, in the court below, that was exhibited.
Exhibit?
The exhibit is
To find the deed.
the deed was in the year 1991 and 1990.
Trial court, first appellate court, find the deed.
Well, on 24th November 1999, the A schedule property was gifted to the plaintiff in the trial court, who is the appellant, who is the respondent in this appeal. Thereafter, B schedule property was transferred in favor of the
Your Counsel, the exhibits are in a separate box or a
separate file is there.
file, separate file exhibit.
Because that is LCR mortgage. Exhibit. I have to check my lord. Property which was gifted in favor of your client. She should be. Yes, my lord. I am referring to the deed of 24th November 1999, which was executed by the pro forma defendant number 3 in the suit in favor of the plaintiff. Defendant number 3, pro forma defendant number 3, who was the father of the plaintiff. That is exhibit A. That is the reason I.
B and C, kindly come to B and C.
That is their claim.
Nineteen 91, that is their deed.
It was produced. But exhibit B and C, it is their exhibit. So far, that is their defendants. Yes, sir. But I believe that was not produced later on. What was there? Because this is the least, like, not produced, not supplied by them. Because it says, I know that that ought to have been. Yes, my lord. But that is the thing. But here also I do not find two miscellaneous receipts only have been written. শুয়ে দিয়েছে সব এখানে লোক আছে তারপর the appeal preferred by the appellant in the court below was allowed in part.
And I'm referring to the page 33, and page 12 of the judgment delivered by the London Trial Court, London Appellate Court. Under the circumstances, the second paragraph. Under the circumstances, this court is of the opinion that the plaintiff appellants have been able to prove their case to the extent that the defendants have encroached upon the common passage of which right of user was only sold to them by the pro forma defendant, that is the Bishwamohan Dotto, who has died during pregnancy of the appeal before this honorable court, and his legal heirs were substituted. But although they are not appearing, and there is no hindrance upon selling to the plaintiffs the right title and interest and user of the said common passage by the said pro forma defendant. In view of such facts and circumstances, the construction of the defendants, particularly of the windows as well as of the open drain and opening of rainwater pipes, cannot be allowed to remain in the said common passage, as the defendants have no title over the B scheduled property. But the B scheduled property, the title of the B scheduled property remains with the respondent number 1 and 4, who are the husband and wife. And the user right was transferred in favor of the appellant. But they have the right to use, because that is the only passage or only way leading to both the premises. But there in that common passage, this appellant have raised a construction. This construction is comprising of an open drain and rainwater pipes along the walls of the building. That was directed to be removed by the appellate court below. Yes, my lord. B schedule belongs to, title belongs to the claim respondent at respondent number 1 and 4. User right belongs to all. C schedule belongs to the appellant. Next. Yes, madam. Yes, madam. B schedule passage. Kindly allow me to go through so that I can. But this is the portion. All the papers are rightly not with me, right?
That is the difficulty, my lord. That is why I, at the first instance, this is the motion.
Date থাকবে
কাছে নেই, আমার কাছে তো I could not bring all those documents, my lord. That is why. But since this is a pattern matter, I only prayed for only 1 day's accommodation.
শেষ হবে নরম করে
I will.
Yes, this is the plate, madam. Yes, yes. This one. That was one.
But that it has been prepared by the learned commissioner. Learned commissioner in the appointed by the trial court.
No, there was no connection. Plate, your plate.
Yes, ma'am. But thereafter, the first appellate court directed that the defendants are directed to remove the window sets jutting out on the B schedule property and also remove the open drain as well as opening of pipes from the B schedule property within a period of 3 months from the date of the judgment. This is the judgment which has been appealed against. But my simple case is that the passage between my property and their property, the ownership right belongs to me. That is not a disputed fact because the easement right, pre-egress and egress. But it is also believed that a common passage should always remain a common passage for both the parties who are using the same. But they have constructed some windows, erected some rainwater pipes, drains, which are causing problem for both the parties. Not only for me, it is also for them also. And that is why, no, the user right was joined. The ownership lies with my client. Prior to that, originally the entire plot of land, which now belongs to me, the common area as well as their property, that belonged to one person named Vishwamohan Dotto. He was the father of my client and the father-in-law. Because the father-in-law and father, because the wife and husband, both of them were plaintiff in the trial court. My lord, by virtue of but I'm placing that portion.
Deed of sale.
Deed of sale in their favor.
Yes, short deeds.
But it's not there. .
এইটাই থাকবে না, না এইটা
My lord, this is a 1991 deed, sale deed. I have a photocopy of the certified copy, handwritten Bengali. That I understand, my lord. For that reason, this has to be translated.
ওটা
But
কবেকার
otherwise-
ডেটটা, ওটা কবেকার ডেটটা?
13 June 1991. দুটো সেল ডিড আছে।
আরেকটা ডেট আছে কিনা? 13 জুন তো?
13 জুন
একটা পেয়েছি,
আরেকটা আছে তোমার 1992
1992
এর।
টু। From the fight manner, I'm seeing that. দাঁড়া, গৌতম দাস ইচ্ছে হচ্ছে বিশ্বমোহন দত্ত দানপত্র দাতা, এটা দানপত্র দলিল। এবার গেল হচ্ছে গৌতম দাস বিশ্বমোহন দত্ত। বিশ্বমোহন দত্ত ভালো না?
বিশ্বমোহনের থেকে
চিত্রবন্ধ সিন আমাদের মুখ ফেলতো। This document, will, my lord, what I have, my lord, given to your lordship, my lord, will match. One is of, my lord, 13 June 1991. My lord has got it. Yes, from whom we have purchased. And 92 document. Yes. That is with your lordship. Yeah, here, my lord, I could not find the document. Only, my lord, to my lord, the
this is the volume
copy I found.
Volume copy.
My lord, it's of 92.
It
My
will
lord, that
not
means
match. The
92
page numbers
of
will
the
not
date.
match.
It cannot match, my lord, but my lord, the thing will be the same. Both these two deeds were exhibited at B and C. Yes. One was B is of 91 and C was of 92. And two deeds. Now, my lord, they have purchased, they have B and C. Yes, from their, my lord,
That have been withdrawn, taken back.
taken. My lord.
Don't go passage. Common passage. Yes, my lord. অধিকার বিক্রি কর।
It will contain all other matters. Yes, it's fine. I'm grateful to you.
All our friends are doing that. All that should be the Malad, those are here. No, Malad, we have taken back the original. The photocopies are here. একটা দাও তো mark করে দিও।
ফ্ল্যাপ করে দিলে ভালো হয়, ফ্ল্যাপ।
আমি জীবনে দেখেছি নাকি প্রথম দেখলাম ভাই। Both are there, Malad.
Bit number.
Yes, 3109 is the B. 327. Read the what?
দাঁড়াও। The user right. This is not in dispute. Yes. And windows which are getting out on the said common passage, and also the rainwater pipes, drain pipes. So that is creating the hindrance to the right of that passage for which it was kept by the original owner of the property. Well, the plaintiff was my client seeking injunction. The original prayer was for decree. It was not decreed. Not decreed. 10 issues were 12 issues were not 12 issues were framed in the by the trial court, out of which 9 and 10 we could not prove. We could not prove that. That is the reason the trial court refused to pass any degree in our favor. Yes. But the issue number 9 is page 6 of the paper book. Whether the defendant encroached land of descheduled property I'm coming. I'm placing the issues. The issue number 9 is whether the defendant encroached the land of descheduled property, and issue number 10 is whether the defendant number 1 made construction in C scheduled property after sanction plan as per municipal rule. Now I am coming to issue number 9 and 10, which were dealt with by the trial court jointly. These two issues being connected to each other and the other core issues are taken up together to arrive at just conclusion. It is alleged by the plaintiffs that the defendant number 1 encroached a portion of land measuring 1 feet 6 inch of land from B scheduled property, which is the common passageway, and raised construction of box window 2 feet 6 inch slab upon C scheduled property. The box windows and the slab belong to the C scheduled property, the ownership of which lies with the appellant. It is not in dispute. But those portions which advocate commissioner was appointed. I understand.
They have not paid for it.
Only the advocate commissioner appointed by the learned court, trial court. But whoever, Only that can be done. No, no. That cannot be resolved. That is why I am not going to that aspect. Encroaching B schedule property for which?
But no, not reversed. He has kept the order of the trial court the entirely. But last 3 lines he says, kindly come to the appellate court's order. Yes. Out on the BC2 property and also remove open drain as well as opening of pipes from the BC2 property within a period of 3 months from the date of judgment. Here the learned courts, my lord, what they have said, both the courts, my lord, the transfers were of 91, 92 to my client, to the defendants. Yes. Now, court observes that whether the subsequent transfers which were made in favor of the plaintiffs are void or not. But that is
was
the
not the
observation.
issue before the
Yes,
trial
that
court.
was the issue before the trial court. What my learned
That prayer was not even made.
what prayer? It's your suit. Well, तो chief judge.
Yes, ma'am. For which the plaintiffs have prayed for mandatory injunction directing the defendant number 1 to remove the said illegal structures and recovery of possession of the said encroached land upon the suit property. Bereft of unnecessary details, it is admitted position that the suit plot originally belonged to the pro forma defendant number 3, Vishwa Mohan Dotto. The said Vishwa Mohan Dotto transferred C schedule property in favor of the defendant number 1 by executing 2 sale deeds, one in the year 1991 and another in the year 1992. The said 2 sale deeds were proved as exhibit B and C by the defendant number 1. On perusal of the said sale deed being exhibit C, I find that the said Vishwamohan Dotto transferred easement right upon the B schedule passage in favor of the defendant number 1 as common passage. But it is clearly observed by the learned trial court. Again, it transpires that the said Vishwamohan Dotto has executed a deed of gift in favor of, in the year 2003, in favor of the plaintiffs in respect of B schedule property, transferring the same absolutely. But when the said Vishwamohan Dotto has granted easement right upon the said B schedule property in favor of the defendant number 1 by executing the said deeds, then how can he transfer the said schedule B property absolutely in favor of the plaintiffs, again having no right to do so?
Yes.
Therefore, the said transfer of B schedule property in favor of the plaintiffs absolutely is illegal and void. This is the observation by the learned trial. At best, it can be said that both the plaintiffs and the defendant number 1 have common right of usage upon the said B schedule property. The plaintiff, by leading evidence, tried to establish that the defendant number 1 or his family members have never used the said B schedule passage for their ingress and egress upon their schedule property since purchase. But how can such fact discard the right and interest of the defendant number 1 upon the said B schedule passage? My lord, here my answer is, all right. The answer is the right of the defendant number 1 upon the said B schedule passage cannot be extinguished or vanished away. Now the question is whether the defendant number 1 by raising construction of his building upon the C schedule property has encroached a portion of the B schedule passage or not. On perusal of the exhibit B, I find that the defendant number 1 purchased the 0.020 Sahasrangsha of land with standing structure therefrom from the pro forma defendant number 3 Vishwamohan Datta in the year 1992, including the right to use the 4 feet wide owner space as common passage by dint of sale deed dated 320 deed number 327 for the year 1992. Exhibit E and F being the notice issued by the chairman Hooghly Chinchura municipality and the reply given by the pro forma defendant number 3 to the chairman Hooghly Chinchura municipality proves that the said pro forma defendant number 3 Vishwamohan Datta was raising unauthorized construction upon his A schedule property, which was stopped by the chairman Hooghly Chinchura municipality. The plaintiffs claimed that the defendant number 1 has raised construction of his house upon C schedule property by encroaching a portion of B schedule property by constructing box window, etc. The pro forma defendant number 3, Vishwamohan Datta, stated during his evidence that the defendant number 1 encroached B schedule property by constructing sunshade, water pipe and box windows, but on perusal of the final commission report, that is exhibit 10, it appears that there is no such report by the learned commissioner that the defendant number 1 has raised any box window. It is reported by the learned commissioner that sunset has been constructed. It is further reported that the 4 feet wide common passage has been narrowed down at some place measuring 2 feet 8 inches. Learned commissioner, that is PW2, admitted during evidence that the measurement done by her was not according to the scale. She did not tally the measurements of the property mentioned in the 2 sale deeds of the defendant number 1. It is neither admitted by her, it is further admitted by her that the defendant number 1 was not present at the suit property when the learned commissioner conducted her commission work. The plaintiffs admitted in their plaint as well as the evidence that the pro forma defendant number 3 Vishwamohan Datta had transferred the eastern portion of the RS plot number 1177 to Moni Bhushan Datta and Binoy Bhushan Datta, and they surrounded their purchase portion in the year 1984 by erecting boundary wall on the western portion of their purchased land, that is on the eastern side of the B schedule suit property. It is admitted portion that the plaintiffs have not taken any steps for the survey commission of the entire suit plot in order to bring out the correct position of the I cannot alter the fact right now. I cannot change the fact, change or alter the fact right now. But it is also an position the learned court below, trial court, has also observed that in the previous portion, what has been admitted by the learned commissioner, advocate commissioner appointed by the trial court, that is also in the record. The plaintiff admitted that was required to be done. That has not been done. Yes, madam. The plaintiff admitted that there was no survey commission held in respect of the alleged encroachment of 1 feet 6 inch of land. It is not clear from the evidences laid by the plaintiff and pro forma defendant number 3 as to whether the said Moni Bhushan Datta and Binoy Bhushan Datta did not encroach any portion of 4 feet wide passage B schedule property at the time of raising their boundary wall on the western side of their purchased land. It has been held by his lordship in Payani Achyutan's case as reported in AIR 96. I'm not referring to this portion, my lord. The defendant Probir Kormokar, DW2, admitted that there is no space has been left from B schedule property at the time of raising construction, but on perusal of the exhibit N, being the agreement executed in between the plaintiffs and the defendant number 1, that no space will be left at the time of raising construction of house. Moreover, the pro forma defendant number 3, Vishwamohan Datto, admitted during his cross-examination that defendant Probir Kormokar raised construction in the year 1992 and he did not apply before the municipal authority complaining about the unauthorized construction raised by defendant prior to executing gift deed in the year 1999 or 2003 or in the year 2004. Thereafter, again the reference to the judgment delivered by the Honorable Apex Court. In view of the above discussions, I find that the plaintiffs have failed to prove the illegal encroachment of any portion of the scheduled property by way of illegal construction by the defendant upon the scheduled property, and accordingly both the above issues are decided against the plaintiffs in negative. But this is the observation made by the trial court while dealing with issue number 9 and 10. Dismiss the suit as a whole. As a whole. The first appellate court only did not also allow my appeal in full, but only directed them to remove that. Yes. Only this is the portion allowed by the court, learned appellate court bill. But I believe this is not a case where the appellant would be, appellant's right title will be jeopardized by any stretch of imagination. But what the trial court observed, since they have been given the right of user in 91 and 92, I'm stressing upon the point of right of user, because I'm coming, my lord. My lord, the trial court observed that since they are having the right of user, the pro forma defendant number 3, Vishwamohan Datto, ought not to have transferred the suit property, that is the B schedule property, in favor of the plaintiffs, in favor of the respondent number 1 and 4 in absolution. That point, the trial court was of the view that this common passage should remain the common passage. Yes, even if I accept this proposition, that is a gift deed. Yes, my lord. No, the right of user. Right of user. I'm not disputing that. I'm not disputing that. But the thing is that when the yes. With regard to that B schedule. That is, even if we transfer the property, that will remain. C schedule property, which is jutting out over the B schedule property, and the rainwater pipes and drain pipes.
In that case, yes.
That is the only point. They have challenged that thing.
In that case, he has to prove that there is encroachment.
This is not the trial court.
Yes.
This is not the trial court.
This is
We
not
are
a trial
sitting
court.
in
The
the-
observations of both the courts. My lord, kindly come to page 32. My lord, what the commissioner's report says, that is restricted to a sunset. That is restricted. It is not, my lord, sunset normally, my lord, 1 feet, half feet, my lord, it will be there. My lord, the shoot was for recovery of possession. Initial, my lord, the shoot was for recovery of possession of that, my lord, CC2 property. On the ground that there was encroachment in that, my lord, passage. My lord, he has failed to prove that part. Unless and until he proves the encroachment, my lord, the next part will not divulge, my lord. Or that the, my lord, yes, can you see? Yes, can you see? I am reading the prayers. He says he has to recover BC2 property also. The property which I got in 1991.
No, they have not got it in 1991. Their
Yes.
user right was given. That does not mean that the title belongs to them.
Definitely. This one is of 2005.
2005. Being the officer of the court as well as the student of law, I must say that at least this property should remain common for all the parties.
Unless and until he proves.
Not absolutely. Nobody. Let me come on that point on the next date, my lord. But let me come. I will prepare a short notes of argument and I will place
কার
it
হয়ে? ওর
also.
হয়ে না আমার? না কার হয়ে?
তোমার এত অসুবিধাটা কোথায় হচ্ছে গো? Municipality actually has no right of audience because they are
You have
even
lordship's order, but we are here. In the suit, in the appeal, we did not contest the
তুই এখানে কি করছিস? বিল করাচ্ছিস?
on the next date I will.
My lord, here, my lord. My lord, it's both the courts decided.
My lord,
in my
the
favor, my lord.
citations, I believe, apart from all other issues, citation comes last. First, the fact which must be corroborated by the law. Thereafter, the citation, if any. My understanding, I may be wrong. I do not know. That can remain.
Encroachment. He has to prove, my lord, that there is encroachment. My lord, nowhere he has
That has
proved
been
that there
proved
is
in the
encroachment.
trial court, but the trial court did not accept that proof as a conclusive one. That is why the first appellate court passed that order.
Yes, my lord, one line, fourth sentence, my lord, I will read for your lordship.
My lord, only one prayer, my lord. Any date after 10th of February.
10th of February. প্রয়াগ যাবি নাকি?
না প্রয়াগ যাবো না, আমি প্রয়াগ যেতে পারবো না, কারণ আমার
এবার সিরিয়াস প্রবলেম আছে আফটার 10 থেকে দেখা যায় আর কোথায় যাবো ওই একটাই তো জায়গা ভারতবর্ষ
Mostly. Only few points are to be clarified with
You
regard to
are-
that commissioner report.
no point no point
Madam. Yes, ma'am.
My problem. Yes, yes. Yes, my lord. We will
Mostly,
be
I have
banking
gone
of-
through.
We will be, my lord, B and C are the লাইটটা বন্ধ করো B and C
But I have gone through all the documents are there, but